My name is Joanna Pruitt. I am 43 years old. My father's farm sat on 87 acres in Giles County, Tennessee, red clay soil, a creek running the eastern boundary, a machine shed my grandfather built in 1961, and a farmhouse where 4 generations of my family had lived, argued, eaten Sunday dinners, and buried people they loved in the small plot behind the cedar grove at the back of the property. My father died on a February morning when the ground was still frozen. He left the farm to both of his daughters equally. In a will he had signed with 2 witnesses and a notary at the office of an attorney named Harold Cates in Pulaski. My sister Brenda knew about the will. I know she knew because she was in the room when my father signed it. She sat in the chair beside the window and watched Harold Cates explain the terms and watched my father write his name at death the bottom and watched the notary press her seal into the paper. Brenda knew. And 10 weeks after my father's funeral, she drove to the Giles County Register of Deeds office on Public Square in Pulaski with a deed of conveyance that transferred sole ownership of those 87 acres to herself, signed with my name, in handwriting that was not mine. The clerk at the counter that morning was a woman named Ruth Ann Gibbons. Ruth Ann had processed the paperwork for my father's property tax filings for 11 years. She had met me at the counter a dozen times. She looked at the deed Brenda set in front of her, looked at the signature line, and said, "Honey, I have seen Joanna Pruitt's signature more times than I can count. And that is not it. This is everything that happened after Ruth Ann said that sentence. My father, Cecil Pruitt, farmed that land for 41 years. He grew grain sorghum in the lower fields, kept a kitchen garden my mother had planted that he continued maintaining after she died, and ran a small hay operation that paid the property taxes and not much else. He was not a wealthy man. The farm was not a wealthy asset. In the liquid sense, it was worth what comparable land in Giles County sells for, which in the year he died was running between $3,200 and $3,800 per acre depending on the road frontage and the soil report. 87 acres at the midpoint of that range is $305,000. Not nothing, particularly not nothing if you are Brenda Pruitt Harlan, who had been living in a rented house in Columbia, Tennessee, with a car payment she had mentioned 3 times over the past year, and a husband named Roy, who had been between steady work since a roofing company he had invested in dissolved in a dispute that nobody in my family had fully understood. I am not going to characterize Brenda with more certainty than I have. She is my sister and I loved her for 40 years before the February that changed what that word means to me now. What I can say is that she knew the farm's value. She knew my father's will. She knew I lived in Knoxville and had a job as a hospital administrator that kept me busy in ways that could be exploited by someone patient enough to move quickly during a window of grief. She had opportunity, she had motive, and she had apparently decided that 40 years of being sisters was not sufficient counterweight to either. Here is what she did, as I later reconstructed it through the title company's records, the Register of Deeds filing log, and the subsequent investigation by the Tennessee Bureau of Investigation. Within 3 weeks of my father's funeral, Brenda had contacted a real estate broker in Pulaski named Dale Sutton and listed the property for sale. She represented herself to Sutton as the sole heir of the estate, explaining that her sister, meaning me, had agreed to quitclaim her interest and that the paperwork was being finalized. She accepted an offer from a buyer named Glenn Partlow, a neighboring landowner who had wanted to expand his operation several years, and who paid $289,000 for the property, which was slight, under market but a clean all-cash transaction that would close quickly. A deed of conveyance was drafted by the title company Sutton used, a firm called Cumberland Title Services in Columbia. That deed required both my signature and Brenda's, because the will had established joint inheritance and the succession had not yet been formally adjudicated in the probate court, meaning both of us were technically on record as heirs. Brenda signed her own name, then she signed mine. She brought the deed to the Giles County Register of Deeds on a Thursday morning in late April. Ruth Ann Givens was at the counter. Ruth Ann looked at the deed. Ruth Ann looked at the signature. Ruth Ann said what she said. Brenda told her that I had signed it by mail and that the signature might look a little different because I had been under stress. Ruth Ann said she was going to need to make a call before she processed anything. She asked Brenda to have a seat. She went to her supervisor's office. The deed sat at the counter. Brenda sat in a chair by the window for approximately 6 minutes before she picked up her purse and walked out of the building. Rusam called the office of Harold Cates, my father's estate attorney. Within the hour, Harold called me that afternoon. I was in a budget meeting at the hospital. I saw Harold's name on my phone and stepped into the hallway because Harold Cates did not call people during business hours to chat. He told me what had happened, what Ruthann had seen, and what Brenda had done before she left. I stood in the hallway of the hospital's administrative wing and listened to him explain that my sister had attempted to sell my father's farm by forging my signature on a deed of conveyance. I stood there for a long time after he finished talking. I was not crying. I was not yet angry in the way that moves you to action. I was in the specific state that comes before both of those things, the state where your mind is running the calculation of whether the information you just received can possibly be accurate and finding no error in the arithmetic. I drove to Pulaski the following morning. I went first to Harold's office on South First Street. He had already made contact with Ruthann and with the Register of Deeds office, and had a copy of the deed Brenda had left. At the counter when she walked out, she had left it behind, which Harold said was either panic or carelessness, and probably both. I looked at the deed. I looked at the signature line. Brenda had signed my name in a hand that was close enough to fool someone who had never seen my signature, but Ruth Ann Givens had seen it a dozen times over 11 years. On property tax documents, on exemption filings, on a deed transfer when my father had added my name to the property record. Years earlier, as a precaution, Ruth Ann knew what my signature looked like, the way a person knows a face. Not because she had studied it analytically, but because she had seen it enough times that the wrong version registered as wrong immediately. And specifically, Harold told me the situation required two things in parallel. First, I needed to file a formal forgery complaint with the Giles County Sheriff's Office, because what Brenda had done was a criminal act under Tennessee Code Annotated 3914114, which defines forgery as falsely making, completing, or altering a writing with intent to defraud, a Class E felony that carries up to 2 years in prison and a fine of up to $3,000. Second, I needed to open the probate proceeding immediately in the Giles County Probate Court because the estate had not yet been formally administered, and the farm's ownership was in a legally ambiguous state that needed to be resolved before anyone, including Glenn Partlow, who had paid $289,000 for a property he believed he was buying legitimately, took an action that created a more complicated chain of claims. I asked Harold whether Glenn Partlow had been notified. Harold said he was contacting Member Land Title Services that afternoon. He said, Mr. Partlow is not the villain here, and he is going to need counsel of his own. I filed the forgery complaint at the Giles County Sheriff's Office on East Minor Hill Highway that afternoon. The deputy who took my statement, a man named Sergeant Alton Webb, was thorough and unhurried. He photographed the deed. He photographed samples of my actual signature from documents I had brought with me, a vehicle title, a bank document, the signature card from my father's estate file at Harold's office. He noted the discrepancies in his report with the methodical attention of someone who took the crime seriously precisely because it was not a violent crime and therefore required him to do more of the analytical work himself. He told me the case would be referred to the Tennessee Bureau of Investigation, given the real estate and financial fraud components. He was right about that. It was referred within 2 weeks. I called Brenda that evening from my car in the parking lot of the sheriff's office. She answered. She did not sound surprised that I was calling. She sounded, of all things, tired. I said, Brenda, I know what you did. She said, Joanna, I need you to listen to me. I said, I am listening. She said, that farm was not doing you any good sitting there. You live in Knoxville, you have a career, you have a life. I could use that money right now in a way that you cannot understand. I said it was half my farm. She said you were never going to sell it. I said that was my choice to make. She said, Roy and I are in a bad place financially. I am trying to hold things together. I said, by forging my signature on a deed and walking into the Register of Deeds office. She went quiet. Then she said, I did not think it would get this far. I said, Brenda, you left the deed on the counter and walked out of the building. She said, I panicked. I said, I know, I have the deed. I am filing a complaint. She said, are you going to have your own sister arrested? I said, I am going to have the person who forged my signature arrested. You decided to be that person. She started crying. I let her finish. Then I said, I need you to not contact Glenn Partlow or Dale Sutton or Cumbrian Title Services or Harold Cates or anyone involved in this transaction. She said, Joanna, please. I said goodnight. Brenda, I ended the call. I sat in the parking lot for a few minutes. A starling was doing something on the power line above the entrance. I watched it for a while. Then I drove to the hotel I had booked on North First Street because I was not ready to stay at the farmhouse alone and I was not staying at Brenda's. The TBI investigation moved with the deliberateness that real estate fraud cases require. Special Agent Paula Denton was assigned to the case. She called me within 10 days of the referral. She was organized and direct and asked questions in a sequence that told me she had already reviewed the documentary record Harold had provided. She confirmed that Cumberland Title Services had been cooperative. They had flagged the transaction. Internally, when Harold contacted them and had held the settlement funds, which had not yet been disbursed to Brenda, pending the investigation, Glenn Partlow had retained an attorney in Columbia named Susan Hollis, who was in contact with Harold about the status of the sale contract. The $289,000 had not changed hands. The farm had not changed hands. The deed Brenda had brought to Ruth Ann's counter had not been recorded. Ruth Ann Givens had in the 40s. It took her to look at that signature and say what she said, prevented an $289,000 real estate fraud from completing. I thought about that a great deal in the weeks that followed. 40s and 11 years of processing my father's paperwork and the specific kind of attention that comes from genuinely caring about the work in front of you rather than processing it as volume. Agent Denton told me 6 weeks into the investigation that Brenda had retained a criminal defense attorney in Nashville and had given a statement. She did not tell me what the statement said, but she said the investigation was proceeding and that charges were being considered. She said, Ms. Pruitt, I want to make sure you understand that your cooperation through this process is valuable and that we are treating this seriously. I said, I appreciate that. She said, I also want you to know that I spoke with Ruth Ann Gibbons last week. I said, how is she? Agent Denton said, she wants you to know she is sorry she could not stop your sister before she left the building. I said, please tell her that what she did was enough, more than enough. Agent Denton said, I already did. The probate proceeding opened in the Giles County Probate Court. Judge Warren Lindsay presided. Harold filed on my behalf as executor. My father had named me executor in the will, which Brenda had apparently hoped to route around entirely by recording the fraudulent deed before anyone opened probate. The probate proceeding established, formally and on the court record, that the estate consisted of the 87 acres and contents of the farmhouse, that the will was valid and properly executed, that the attempted deed transfer was void as a matter of law because it bore a forged signature, and that Glenn Partlow's purchase contract was unenforceable as applied to the full property because the seller had lacked authority to convey my interest. Glenn Partlow's attorney, Ann Harold, reached a resolution in which Partlow's earnest money, deposit $15,000, held by Cumberland Title Services, was returned to him in full. Partlow had been a victim of Brenda's fraud. In the narrowest sense, he had engaged in the transaction in good faith and had come close to paying nearly $300,000 for a property that could not legally be sold to him. He wrote me a letter, through his attorney, saying he harbored no ill will toward me personally and understood I had not been a party to what he called the irregularity. I found the word irregularity generous under the circumstances. Brenda was charged by the Giles County District Attorney's Office with 1 count of forgery under TCA 3914114, 1 count of theft over $60,000 under TCA 3914103, because the attempted theft of my half interest in the property at its assessed value placed the offense in the Class B felony range, and 1 count of fraudulent conveyance. The forgery charge was a Class E felony. The theft charge, at the value involved, was a Class B felony carrying between 8 and 30 years. I did not know when the charges were filed whether Brenda fully understood what a Class B felony in Tennessee meant for the rest of her life. I assumed her attorney had explained it. I assumed it was a conversation that had been difficult to have. She called me from her attorney's office the week the charges were formally filed. Her attorney was on the line as well, a man named Carter Hines, who identified himself at the start of the call and whose presence I appreciated because it meant the conversation would be conducted with a witness and some degree of structure. Brenda said, I want to tell you I am sorry. I said, I am listening. She said, I convinced myself that you would not miss it, that you had moved on and the farm was just a. She stopped. I said, just a what, Brenda? She said, just a piece of land. I said, it is where Dad is buried. She was quiet. I said, it is where Mom is buried. It is where Grandpa's machine shed is. It is where I went the morning after Dad died and sat on the porch for 2 hours because I needed to feel where I was from. It is not just a piece of land. She said, I know that now. I said, you knew it before. She did not answer that. Carter Hines said, Joanna, we are prepared to discuss restitution terms as part of a plea agreement. If that is something you and your attorney would like to consider, I said, Harold Cates can talk to you about that. I said, Brenda. She said, yes. I said, I need you to understand that I am not doing this because I am angry at you. I am doing this because you forged my name on a legal document and attempted to sell land that belonged to our father, and both of us, and I am not able to pretend that is the kind of thing we work out between sisters without consequence. She said, I understand. I said, I do not know if we get through this. I want to believe we do. But I need you to be honest about what you did before we can talk about anything else, Carter Hines said. I think that is a reasonable position. I thanked him and ended the call. The plea agreement took 4 months to negotiate. Harold worked with Carter Hines and the DA's office on the terms. Brenda pleaded guilty to 1 count of forgery, the Class E felony, and 1 count of theft, over $10,000, reduced from the Class B felony through the plea, bringing the theft charge to a Class D felony. The more serious charges were dismissed as part of the agreement. Sentencing: 3 years of supervised probation, 300 hours of community service, a fine of $4,500, and restitution of $14,200, representing the legal costs the estate had incurred through the forgery, the TBI investigation, and the probate proceeding. Roy, Brenda's husband, was not charged. The investigation found no evidence that he had been directly involved in the execution of the scheme. Though Agent Denton told me the financial pressure he and Brenda had been under had been well documented in the course of the investigation, I did not feel vindicated by that information. I felt tired. I did not attend the sentencing hearing. Harold represented the estate's interest. Afterward, he called me and read me the judge's remarks, which included a statement that the defendant had exploited a period of family grief to commit an act of fraud against her own sister, and that the court took the matter seriously, regardless of the resolution through the plea process. The judge noted for the record that the fraud had been detected not through a sophisticated forensic process but through the attentiveness of a county employee who had done her job carefully for over a decade. He said Ruth Ann Gibbons's name in the courtroom. I was glad for that. The farm is still in the family. The probate court issued the judgment of possession in my name as sole heir under the will. Brenda's interest had been addressed separately by Harold and Carter Hines as part of the plea resolution, with Brenda formally disclaiming any inheritance claim in exchange for the reduced charges and an acknowledgement of the harm caused. I did not ask for that outcome. Harold and Carter Hines reached it through their negotiation and presented it to me. As a fait accompli that I could accept or contest, I accepted it, not because I wanted Brenda's share, because the farm had to belong to someone who would treat it as more than $305,000 of convertible equity, and I was the one left who met that description. I went back to the farm on a Saturday in October, after the probate closed and the judgment was recorded. I parked at the end of the lane and walked the property the way my father used to, eastern boundary along the creek first, then up through the lower fields, then past the machine shed where the John Deere 4440 he had bought secondhand in 1994 still sat under a canvas tarp I had not yet decided what to do with. The cedar grove, at the back of the property, the small plot inside it, my father's stone, new enough that the granite still looked sharp at the edges, my mother's stone, worn enough at the corners that the year she died had softened into the rock, the way years eventually soften into everything. I stood there for a while. The starlings were working the upper field, the same kind I had watched from the sheriff's office parking lot in April, or different ones, it does not matter. And the light was doing what October light does in southern Tennessee when the angle drops and everything goes the color of the soil. I want to say something to anyone who has property in a family estate that has not yet been formally administered. Please do this one thing. Open the probate proceeding as quickly as the law in your state allows after a death. Do not wait. Do not assume that the will's existence is sufficient protection against someone acting before the court establishes the record. In Tennessee, and in most states, an unrecorded will is not a substitute for a probate judgment. Property can be transferred or attempted to be transferred before probate closes. If someone is motivated to try it and you are not paying attention, the cost of opening probate promptly is the cost of a few hours of an attorney's time. The cost of not doing it, in my case, very nearly included 87 acres that 4 generations of my family had worked, and where 2 of them are buried. Open the probate, find an attorney, do it in the weeks after the funeral, not the months. Grief is real and it slows you down, and your family members know that, and some of them will use it. Brenda and I have spoken twice since the sentencing, both times briefly, both times by text message. She said, I think about Dad's farm every day. I said, so do I. She said, I hope you do something good with it. I said, I am already doing something good with it. I am keeping it. She did not reply to that. I did not expect her to. The conversation we need to have, the longer one, the one where we figure out whether 40 years of being sisters survived what she did in those 10 weeks, is not a text message conversation. It is the kind of conversation that requires sitting across a table from someone in a room without phones, without attorneys, with enough time and enough honesty to find out what is still there. I do not know when that conversation happens. I know that Ruth Ann Givens made it possible by looking at a piece of paper and trusting what she knew. I know that Harold Cates made it possible by picking up the phone. I know that my father made it possible by sitting in Harold's office with 2 witnesses and a notary and writing his name at the bottom of a document that said what he wanted and why. He did not know he was protecting the conversation I still need to have with his other daughter. He was just doing what careful people do. He was getting his papers in order. I am glad he did.